and welcome to, good evening everyone, and welcome to the webinar that is jointly hosted by the GPA and Dental Protection. You will know that since the beginning of 2021, we, the GPA and Dental Protection, have been partners in providing indemnity cover to the dental profession. These kinds of webinars are very important because part of what Dental Protection and the DPA wants to do is to assist the dentists to practice to the highest possible ethical standards. And we do so by having webinars like this. And in addition to these webinars, there are other resources that Dental Protection has put at our disposal that will assist us in getting to grips with all the ethical issues that we need to know. Tonight's webinar is entitled HPCSA Moments of Truth, and we shall be dealing with actual cases that the DPA has been dealing with relating to to the unfortunate incidents involving dentists and their patients. Our guest tonight is Alisdais McKelvie, Dr. Alisdais McKelvie, who is no stranger to most of us. He is the head for Southern Africa, the head of dental services for Southern Africa, and is working for Dental Protection. Our second guest is Dr. Yash Naidoo. Some of us will have gone to university with him here in South Africa. He is the case manager in South Africa for Dental Protection. And lastly, we have Ms. Zodwa Mahlangu, who is the relationship manager for Dental Protection relating to the DPA. Yes, we will start right away. The first person who will give us a talk is Dr. Alisdais McKelvie. I will ask him to briefly introduce himself, followed by Dr. Yash Naidoo, and Ms. Zodwa Mahlangu will finally tell us about a few things that we need to know relating to the application process for dental protection. Okay, we will start with you, Dr. McKelvie.
Good evening, Tabo. It's good to be working with you again, and the DPA, Dental Protection, in partnership with the DPA. And I was sorry to hear that there's some load shedding tonight in South Africa, and that's a shame because it might have an impact on how many of you are able to attend this webinar tonight. So it's good that it's being recorded because that will maybe allow people to watch it afterwards if they've been unable to join us tonight. So yep, my name's Alisdais McKelvie, Head of Dental Services for Southern Africa. I've got my colleague and good friend here, Dr. Yash Naidoo, to help me tell you a little bit about the moments of truth, and Zodwa at the end of the presentation to tell you a little bit more about how you can join Dental Protection if you're not already a member. So the title of the talk is HPCSA Moments of Truth. And Yash and I thought it was about time we took a look at some of our favourite ethical transgressions and some of the more common problems arising from HPCSA complaints and the investigation of those complaints. Now, I don't know if patients and sometimes other colleagues really understand the impact and potential consequences of reporting a dentist or a therapist or even a hygienist to the HPCSA. Many of the complaints that we see follow a breakdown in communication over some very simple problems that have been left to fester, and probably a lack of empathy for each other's perspectives and context. But the investigation and the consequences of a sanction or worse keep most of us awake at night. And that's when you need dental protection, because we've been assisting colleagues like you for over 60 years in South Africa. And the evidence shows that those colleagues who have representation before the HPCSA, or any regulator for that matter, have better outcomes. Now, I also want you to keep a thought in the front of your mind all the way through this talk tonight, and it's this. The function of the HPCSA, the responsibility of the HPCSA is to protect the public and guide the profession. And the rules exist to fulfill those two key objectives. And as we describe the various examples, various case examples, you can work out yourself what objective each rule achieves. So just before we start the presentation, I just wanted to remind you of a few house rules, and we're keen for you to ask questions. If there's something that you're not sure about or a specific question you want to ask, then type the question in the QA function at the bottom of your screen. The second thing I want to mention is that there's a feedback survey at the end of the event tonight, and we really welcome your feedback. It's always difficult to know how much you enjoyed the webinar and what other topics you'd like us to cover when we're virtual. So when we're in front of you, we can talk and we can have a conversation after the presentation, but when we're virtual, it's not so easy to do that. So your feedback helps us identify what you need and what you think. So please take time to tell us what you want and what you think about the webinar in the survey. You know we're recording this webinar because I've already said so, and this event is eligible for 1 CME point. So let's start by talking about annual renewals, because every year in every jurisdiction, dentists and oral healthcare practitioners forget to pay their annual registration fee. In the United Kingdom, it's absolutely brutal. The renewal date is by the 31st of December for the following year. And it's a time when everyone is wrapping Christmas presents up, going to parties, and folk forget to renew. And they are removed immediately by the GDC, and they have to stop working until restored to the register. If you forget to pay, you usually forget you can't work. Now, in South Africa, the Health Professions Act requires your registration to be suspended by the HPCSA for non-payment after 3 months from the due date. And the most common reason for folks forgetting to pay the renewal is because the HPCSA don't have your correct up-to-date contact details. So it's your responsibility to make sure the HPCSA hold up-to-date contact details so they can contact you. Now, if you allow yourself, whether you know it or not, to be suspended from the register, and if you continue to practice, continue to treat patients while you've been suspended, you will be acting unlawfully. And the HPCSA make it very clear that once suspended, you must stop practice immediately. If you do continue to practice while suspended, you will be committing an offence. You will also be unable to charge fees and claim fees from medical aids for treatment undertaken during that period. And unregistered practice, a period of unregistered practice because you've been suspended, may invalidate your indemnity or your insurance if a claim arises from treating a patient during a period of unregistered practice. So once you're suspended, you need to reapply to go back on the register. You've got to pay a registration fee. And then you probably have to provide the Committee of Preliminary Inquiry with an explanation as to how it all happened. And they will then sanction you for poor admin and for unlawful practice, leading to another fine. So it's an expensive and stressful business if you forget to pay your renewal fee and if you allow yourself to be removed from the register. So this registration permits the HPCSA and the South African Police Force to prosecute illegal and unlawful practice, and therefore it protects our patients from unlawful conduct, or at least acts as a deterrent to anyone who thinks they can just pitch up and open a dental practice and treat patients without being registered as a dentist. So the purpose of being registered is twofold. It's to make sure that patients are reassured that the person they are treating is a registered dentist. And the second thing is it's to act as a deterrent to stop anyone else pitching up and pretending they're a dental professional. So the next topic is about scope of practice. Now, your scope of practice describes the services that a registered healthcare practitioner is deemed competent to perform and permitted to undertake. So the nature and extent of your undergraduate and postgraduate training underpins your scope of practice. The scope protects our profession. The scope makes it unlawful for anyone else to practice dentistry who's not registered in one of the oral health registers. Each board publishes the scope of each individual category of registrant. So there is a list of procedures only a registered dentist can undertake. And there are also distinct scopes setting out the procedures therapists, hygienists, and dental assistants can carry out lawfully. So Ethical Rule 21 has to be read in conjunction with your scope of practice. And this rule creates an obligation to limit your practice, to limit what you do, to the performance of professional acts for which you've been adequately educated, trained, and are sufficiently experienced to carry out. And this is all pretty obvious to all of us. The adequately trained part comes from our undergraduate curriculum, and for specialists, it comes from their postgraduate training. It relates to procedures and skills that are listed within the scope definition. So the idea here is that you are trained and competent to provide treatments in scope from your undergrad and postgraduate curriculum. If they work effectively, these rules should protect patients from being serviced by dentists with treatments that they're either not skilled to provide or don't have the training or experience to provide or are not within the scope of practice of a dentist. Now, this slide headed Interpretation of Ethical Rule 21 was given to me by Dr. Quinda of the HPCSA a couple of years ago when we did a roadshow together. And of interest is section DD at the bottom of the slide, which describes the purpose of short courses, which are only recognised by the HPCSA as being necessary to enhance and maintain skills within your scope of practice. These short courses do not allow you to learn new treatments or skills for interventions that are not included in your scope of practice. And the most obvious problem we all now have is that many of you are providing non-surgical aesthetic treatments with Botox, fillers, and other dermal therapies in areas other than around the perioral area. And this is not part of your undergraduate curriculum or training. And let's look at the Botox issue in a little bit more detail, because this is really important. So within scope, we can see that dentists are permitted to perform aesthetic or cosmetic procedures in the oral and perioral area only. Okay, this is around your mouth. It's not the forehead, it's not the ears, it's not the neck. It is around your mouth that you are allowed or you are permitted to provide aesthetic or cosmetic procedures on your patients. And what this seems to do is seems to create an offence for any other registered group or non-registered group to undertake Botox or fillers of the lip as an example. So I'm going to argue here that the only people who can plump up lips are going to be dentists because it's within their scope of practice, unless it appears in somebody else's scope of practice, the plastic surgeons, for example, or maybe the dermatologists. But on the other hand, if a dentist undertakes the treatment of furrowed brows and a forehead, that would be outside the scope of practice for a dentist. And you might find yourself charged with unprofessional conduct if a complaint was made to the HPCSA by one of your patients who they're unhappy with the result, or maybe by another professional colleague who doesn't think you should be doing the work on the patient's forehead. We actually don't know what position the HPCSA would currently adopt upon investigating such a complaint, but we know dentists have been charged with working outside scope of practice when they provide these treatments beyond the oral and perioral area, because it's happened. But there is inconsistency in the way the HPCSA investigate and sanction these matters. Now, Dental Protection have written to the Dental Board on a number of occasions for clarification of this issue, because we think that dentists are quite capable of providing Botox and filler treatments beyond the oral and perioral area. We're good at injections, we're good at injecting things, and we're good at facial aesthetics and looking at faces and getting the harmony right. We're probably better than most other professionals, but surprise, surprise, the HPCSA Professional Board for doctors and dentists have resisted any opportunity to advance any discussions on this specific topic. And it causes us as an indemnifier all sorts of problems, because you're at risk of disciplinary action if you carry out these procedures. And as an indemnifier, we cannot provide an indemnity for treatments not included in your scope of practice. So until the HPCSA revisit this problem and perhaps change the scope, we're all in an awkward position, because we cannot indemnify you when you provide treatment of a patient's forehead. And if we did extend our indemnity to include the patient's forehead, then what we would be doing is we would be encouraging you all to commit an ethical transgression. And that's not the type of business that we're in as an ethical indemnifier. So not only can you find yourself in trouble for working outside your own scope of practice, but you can also find yourself in hot water if you allow, for example, an oral hygienist to undertake treatments outside of their scope. So examples may be allowing oral hygienists in an orthodontic practice to undertake basic periodontal treatments and tooth whitening, maybe on a cash basis. Other examples of registrants working outside of their scope may include allowing your registered dental assistant to undertake tooth whitening procedures or take impressions of patients. So it's really important that you all make sure you understand the limits of each scope, because it's unlawful to undertake procedures or allow others to undertake procedures that are not allowed in their scope. So we've been asked on a number of occasions to highlight the risks attached to permitting therapists and hygienists to assist dentists with procedures that fall out with their scope of practice. And this blog from the Professional Board of Dental Therapy and Oral Hygiene highlights the concerns and reminds the registrant of the consequences of disciplinary action against both the employee and the employer dentist. If we look at protecting the public, scope again prevents or should prevent registered oral healthcare practitioners from doing treatment they are not registered and skilled to provide. And we have a case at the moment where a dental assistant opened the practice after everybody had left in the evening to see an emergency patient who she agreed to see, who had toothache and was prepared to pay cash. So she first of all removed the wrong tooth, and then when the patient, she botched a second extraction, leaving the patient with an oral antral communication. Now, not only has she acted out of scope, but she's acted unlawfully and committed an assault on that patient, and I'm afraid she is in serious trouble. So the consequences for anybody doing something unlawful are quite serious. So I now want to move on to talk about supersession. And supersession is the practice of taking over the patient of another practitioner without informing that other practitioner where the patient has not terminated or paid for the first dentist services. Okay, so I'm not actually sure how you would know the patient has not paid the first dentist for their services unless they tell you. But it's fairly obvious if somebody walks in to see you and they're in the middle of treatment, if they've got a temporary crown on a tooth, if they've got the evidence of an unfilled root canal treatment. So it should be fairly obvious that somebody is under treatment. And Ethical Rule 10 sets out your obligations to avoid unethical supersession. So the risk of an unethical supersession occurs where it should be immediately obvious to you that treatment is incomplete and ongoing in the patient who's sitting in your chair. If we break down Ethical Rule 10 into separate components, then the first part of the rule seems to imply that the HPCSA would consider it unethical to take over a patient's treatment from another practitioner when it should be clear to you that the patient is having a root treatment, temporary crowns, or they arrive with a fixed orthodontic brace on. This is not to be confused with a situation where a patient attends for the first time with a dental emergency, or where a patient attends asking you to provide them with a second opinion. To make supersession ethical, you should take reasonable steps to contact the previous practitioner and let them know that the patient has come to you for treatment. And when you contact that other practitioner, you should request information about the ongoing care the patient was having and request copies of x-rays and scans, etc., if they exist, and any other information that helps the continuity of care. Well, what are reasonable steps? Well, a phone call or an email. I mean, it shouldn't be that difficult to be able to contact another practitioner. Should it be clear that to not attempt to contact the previous practitioner must be an ethical fail? So if you do not attempt to contact the previous practitioner when it's obvious this patient is having treatment in the middle of treatment, then that is an ethical fail. Ethical supersession, on the other hand, is where a new patient turns up in the middle of some treatment and you then make contact with the other practitioner and everybody is happy. So what do you do if a patient specifically requests that you don't inform their current practitioner that they've come to you for treatment? Well, this is quite a likely scenario, in fact. Most patients certainly wouldn't know that there was any problem about moving to a different practitioner during treatment. And they probably don't really want anyone to know about it. There can be many reasons why it happens. It can be just down to choice. There could be a fallout. There could be a personality clash. And the patient's wishes need to be respected. So you've got to remember that the very fact that this patient is now sitting in your chair is a confidential situation. And you can only fulfill your duties in respect of Rule 10 if the patient consents to contact their previous practitioner. So the first thing you've got to do is you've got to make sure that the patient knows that you have got this ethical duty. And I've got 4 key tips on this slide to help you avoid the supersession problem. So the first one, if a patient pitches up and it's obvious they're in the middle of a treatment, ask them what's going on. Ask them, why are you here? It's obvious you're in the middle of treatment. Why have you left that last dentist? Tip number 2 is advise the patient that you've got this ethical duty to contact their previous practitioner and explain why it's important that you're doing it. It's actually to help with continuity of care. But the patient's right to confidentiality arguably trumps your ethical duty. So if the patient says, I don't want you to contact the last dentist, then you must not do so. But you must make a note, particularly where that patient withholds consent. You've got to make a note in your record to say that I told the patient I needed to contact to comply with my ethical duty, but the patient did not allow me to do so. So consent was withheld. So from a practical point of view, we're seeing an increasing number of complaints by the superseded practitioner to the HPCSA. And in this case, the dentist reported to the HPCSA was found guilty of unprofessional conduct and was given a sanction. He was given a warning and a reprimand. And you can see there the committee resolved that A, the doctor was guilty of unprofessional conduct, and secondly, at point B, a penalty of reprimand be imposed in terms of section 42 of the Act. The committee felt there was no evidence of supersession as the patient in his own volition chose to consult with the new practitioner, but in future that new practitioner should ensure that this behaviour doesn't occur. So what had happened here? Well, the patient in question was not the one who complained to the HPCSA. It was the orthodontist the patient was seeing, and the orthodontist was correcting the position of some crowded teeth prior to some sort of smile makeover treatment that was going to be provided by a restorative colleague. And the patient was nearing the end of the orthodontic treatment, and he decided to go to a different dentist for the restorative work that had been agreed and hadn't told the orthodontist about it. So the new dentist looked at the patient and felt that he could do the restorative work, the makeover work. So he agreed to provide the treatment. And he actually set about removing the fixed orthodontic braces that were attached to the patient's teeth. He wasn't actually continuing with any active orthodontic care, but he did remove the braces, which was work the orthodontist was due to finish, along with obtaining the post-treatment records, like the impressions and the photographs and whatever. So the orthodontist was really unhappy that the new dentist had actually finished off the orthodontic treatment without involving him, and was unhappy that he hadn't been contacted when it was pretty obvious there was something that needed to be done by an orthodontist. And as I say, it was the orthodontist who reported the treating dentist to the HPCSA. And you can see that the HPCSA still found the dentist guilty of unprofessional conduct, even though he never really took over any active orthodontic treatment. And it was never his intention to do so. But he should have contacted the orthodontist and asked him when he was removing the scaffolding from the teeth, and he just failed to do this. And this is why he was reprimanded and warned about his future behavior. So in this next section, I want to talk about vicarious liability, which is where an employer, a practice owner, becomes responsible for an act or an omission of an employee. And normally this is in relation to negligent acts and omissions leading to an injury and a claim for compensation, but it can also involve the HPCSA and indirectly involve you in an investigation of unprofessional conduct. And I'm going to illustrate the VL point with reference to two cases. The first involved a patient who made a complaint to the HPCSA that he'd not been informed of a co-payment before he had his treatment. And his complaint suggested that had he been provided with the correct fee information, he would not have gone ahead with the treatment. The treatment was provided by Dr. A, who was the treating dentist, and was employed by Dr. B, the practice owner. Now, Dr. B never saw the patient for any part of his treatment and was not in the practice the day the treatment was provided. So he never actually crossed paths with the patient, yet the Committee of Preliminary Inquiry found him guilty of unprofessional conduct. Now, this is the charge, and it's factually incorrect. So the HPCSA said that you are guilty of unprofessional conduct in that on or about 2021, you provided treatment to a patient without consent. This is the actual wording of the charge sheet. Now, Dr. B did not provide any treatment and was not responsible for any part of the consent process, as we argued. And this is another good example to support the feeling being made right now by other organizations, by other dentists, by other associations regarding the administrative incompetence within the HPCSA. The owner of the practice, Dr. B, could never be responsible for the consent process because that remains the duty of the treating dentist, Dr. A. The complaint also arose from an incident on the 6th of March 2012, not in 2021, but was only resolved in 2021. So you're probably scratching your heads wondering, how can it possibly take the HPCSA over 9 years to resolve a complaint about a co-payment? And can you imagine what it's like to be the dentist waiting 9 years for the HPCSA to make a decision and possibly sanction you? And the final problem we all have, and when I use we, I'm talking about the dentist, but I'm also talking about the indemnifier and the attorneys that we use, is that the HPCSA do not explain the reasoning behind their decision to charge a dentist. So it's left to the attorneys and dental protection to try and work out how a dentist who never saw a patient could be charged for providing treatment, which he never did, and in the face of it, could not be responsible for the cost elements of the consent process. So what does this decision mean? Is it the wrong decision? And what do we learn from this decision? What do we learn about the thinking of the HPCSA? Well, it's a matter of law and ethics that a healthcare practitioner is required to inform a patient of, amongst other things, the costs associated with each treatment option available to a patient. And the process of obtaining informed consent can be delegated by a healthcare practitioner to another person who is suitably educated, trained and qualified, has sufficient knowledge of the proposed investigation or treatment and understands the risks involved, and acts in accordance with the booklet on informed consent. So the HPCSA accept that the consent process can be delegated. So on this occasion, the treating dentist, Dr. A, who was employed at the practice, had not discussed the co-payment with the patient and had delegated that duty to the receptionist, who had advised the patient that there would be codes not covered by his medical aid. But crucially, the amount in Rand was not given, which was about 400 Rand. So how did the practice owner find himself responsible for informed consent with the patient he never saw? Well, it all flows from him being vicariously liable in the eyes of the HPCSA for the acts and omissions of his employees. So both dentist A and the receptionist were employed by dentist B, and the HPCSA held him responsible for the fact that the information about the costs of treatment were not properly discussed. And the only way he could have abrogated that responsibility was to provide the HPCSA with evidence that he had provided all his employees with a copy of the practice billing policy and had written evidence in the practice that he'd provided the same employees with the necessary training to comply with the billing procedures. So the moral of the story here is that if you are a practice owner and you do delegate the cost discussions to your receptionist, make sure that you have a written policy and evidence of training so that you can defend yourself in such a situation and prove, apart from the other, you had done everything in your power to make sure your staff fulfilled your delegated ethical and professional obligations. And whilst we're on the subject of consent, we've seen an increase in the number of complaints and requests for assistance following endodontic file fracture. Now, in every single case that I've looked at, the patient wasn't warned about the risk of file fracture. And if we're, as a profession, going to continue to view file fracture as a recognized complication of endodontic treatment, then we need to have informed our patients before we begin. Now, endodontic instruments do break, they're not robust. You've got to use them correctly, and particularly the rotary files need to be used in the correct handpieces. The patient also needs to know the instruments have to be used in very narrow root canals, and they also need to know that even in the best of hands, breakages occur. The consent process for endo needs to be specific for the tooth you're working on. And if there's an increased risk because of the root canal anatomy, then the patient needs to know this. And you also have to explain what will happen if a file breaks and what further treatment will be necessary. And that the costs of that further treatment, the costs of recovering the file, even by somebody who's got a microscope, need to be borne by the patient. And it might mean a very small number of patients choosing an extraction instead of a root canal procedure, or a very small number of patients asking to see the endodontist in the first place. But it is the patient's right to make the choice based on being given the correct information. And in nearly every case we've seen in the last 12 months, the consent has been invalidated by the lack of information. Now, if a complaint is made to the HPCSA, then the prelim committee will look at the consent, and if it's deficient, they will make a finding against you. If you give your patient the correct information in the consent process, you won't have to ask us what to do when the patient says they're not paying for the file recovery procedure, because you will have already told them that they will be doing that. And if the patient litigates in the small claims courts, the judge will side with the patient every time where the consent has been invalidated by the lack of information. If you fail to warn the patient, then it's very difficult to defend that you've done the right thing and the patient has had all the information to make an informed decision. So let's stay on the topic of vicarious liability, but in relation to a claim for injuries caused by the negligent treatment of another dentist or maybe another therapist or hygienist treating patients in your practice on your behalf. So as a practice owner, you might be comfortable in the knowledge that you have indemnity yourself, but in reality, you are only indemnified for your own clinical risk and not the risk created by other clinicians who work for you. So to be vicariously liable for the work of a therapist and other dentist, the patient has to establish that the relationship between you and the treating clinician is akin to an employer-employee relationship. And if they can succeed in that point, and they may do because of the work arrangements and because there is a poorly worded contract for services between the practice and the treating clinicians, then they will succeed. Now, these relationships, the employer-employee relationship or the independent contractor relationship, are not based only in what is said in a contract, but also on how much control there is over the treating clinician. So it's the things like, do they have to work the same hours every week? Do you deduct tax at source? And it's often the case that the labour courts will presume an employer-employee relationship exists unless the contrary is proven by you or by your attorneys. So apart from having a competently drawn up contract, the other way of mitigating the risk of being held accountable for someone else's work is making sure that all the treating clinicians in your practice are obliged to have their own indemnity and provide proof of that indemnity. So that should be a contractual requirement. So the contract of service between you and the other treating dentists who work for you, seeing your patients in your practice, should be the requirement that they all have their own indemnity and they give you proof that they do have that. If you have treating clinicians working at your practice who do not have their own indemnity, then you have a significant litigation risk yourself. And you could find yourself defending or settling a claim with your own money. In the event that a patient sues the practice rather than the individual treating dentist, then you need to be able to redirect the claim to the indemnifier of the treating clinician. And if they don't have that indemnity, then you're going to be in trouble. So what steps can you now take as a practice owner to make life a bit more comfortable? Well, I've got some practice owner survival tips on the slide here. So the first thing to do, make sure all the clinicians who work for you are actually registered with the HPCSA and that they have their own indemnity. Keep a record of those indemnity arrangements. Make sure you know who the indemnity or insurance is with. Keep up-to-date contact details for all clinicians who leave the practice, because it is quite often the case that claims for failed treatment and claims for negligently failed treatment will come in 2, 3, 4, 5, sometimes 8 years after the treatment was provided. And if the patient is not timed out by the Limitation Act, then the claim will succeed, and the claim will succeed against you unless you're able to contact those dentists. And make sure the contract includes a contractual obligation to indemnify the practice, and that means you, for any loss arising out of their own clinical error. So make sure that the contract between you and the treating dentist has a clause that says they will indemnify you if you have to settle any claims yourself for treatment they had provided. So I'm going to hand over to Yash. Yash, are you there?
I'm there. Thanks, Alistair. Good evening, everyone. Firstly, I must just say I apologize for the weird lighting here on my side. You know, unfortunately, I'm in the 6 o'clock to 8:30 p.m. load shedding slot. So, you know, I was telling Alistair before we started, it must be so nice to be in a place where you don't have to worry about electricity. But anyway, it's fine. We're South African. We are resilient. And so fingers crossed that my battery lasts, but let's get cracking. So the main theme of what I'm going to be discussing tonight is HPCSA investigations, as the slide would imply. And I thought, you know, instead of just coming and listing some regulations, I want to take you down a bit of a story. And when I say story, it's one of those, like in the movies where you see at the beginning, it says based on a true story, because even though it's not 100% true, I've taken bits and pieces which are actually a true story. So it's not made up. And there's elements of actual cases that I've seen in this story. So let's move on to the next slide, Alistair. And you'll see there, I've called this story Getting to the Root of It, the Curious Case of the Confused Colleague. And that's a fun title, but it will hopefully make a bit of sense right at the end. I had to try and make it sound a bit catchy. But before I get into the story, I want to be a bit more serious for the moment and just tell you quite directly what I hope we'll all learn from this story. And on your screen, these are the, if you will, the chapters of the story that I'll go through. So firstly, I'm going to talk about complaints against colleagues at the HPCSA, quite a difficult subject. The next chapter of the story will then be about the real finer details of an HPCSA investigation. And that will then naturally take us to the HPCSA's preliminary committees process. And I'm going to stop at that process insofar as the HPCSA complaints goes. I won't go any further than that. And then lastly, and I know it might seem a bit random to end off this story about HPCSA investigations about what is a locum, but I think it'll make sense and it'll all tie up at the end once we go through the story. And then lastly, we'll also just look at a few learning points which we can pick up on the way during the story. Thanks, Alistair. So, chapter 1, let's start the story by setting the hypothetical scene here. So I want you to imagine this, right? You're the successful dentist in a nice neighborhood, and you've got a busy practice, which I'm sure a lot of you, this actually is a true story. So you've been in this area for years, right? And you've got a nice, solid patient base. But recently, there's a new dentist in town, Dr. Yash Naidoo, who's moved into the neighborhood, and he started his own private practice nearby. Now, you and Dr. Naidoo were in dental school together, and you remember him very well. You weren't friends with him because he was that sort of dental student who, if he even decided to pitch up to school, he was always sitting at the back of the class, playing on his phone, trying to get people's BBM pins and chatting on Mixit. At that time, it was called Mixit. And he was always asking everyone for their study notes before the exam time. You even wonder how Dr. Naidoo made it through dental school, because you'll never forget that one time you were both on duty in an endo session at campus. And Dr. Naidoo was obviously Mr. Naidoo at that time. He didn't place a rubber dam properly. The poor patient ended up drinking some bleach and choking. So you'll never forget that moment. But you, on the other hand, you were top of the class. You even won the endo award in final year. And so you were the star student. Chalk and cheese, you and Dr. Naidoo. Anyway, back to the story. So after a few months with Dr. Naidoo and his new practice in town, you start to notice something strange, but it also doesn't surprise you. And what you notice is that you're getting a lot of patients coming into your practice who have just recently been to Dr. Naidoo's practice. And the funny thing is they all have the same problem, failed endos, right? And on every single one of them, you see there's either been a missed canal or a failed obturation, or sometimes even the adjacent tooth was actually the problem and it wasn't addressed. But whatever the issue is, it has to do with endos. And you notice that these patients are being seriously mistreated when it comes to endodontics. And this pattern, it carries on for a few months. And it's not bad for your business because you're picking up more patients, but you are part of the community and you become more and more concerned about the well-being of the patients in your community. And eventually it carries on so long that you can't take it anymore. You decide you need to put a stop to this. You need to take care and protect the community. Now, unfortunately, at this stage, you don't call dental protection for some advice. But instead you say, let me just Google this. You go onto the internet, you go onto the HPCSA's website, and you find the complaint form and you fill it in. And what you do is, because you want to show to the HPCSA how serious these things are, you write a comprehensive report about Dr. Naidoo. And here's an important thing. You also say, I attach the relevant clinical records belonging to these, these poor patients that have come to you over the past few months, just to try and show, how serious things are. And you tell the HPCSA, please, can you look into Dr. Naidoo? Now, I can picture it. Some of you listening to this right now might be thinking, firstly, who is this dentist that's going and complaining about a colleague? But some of you might have also picked up another problem for the complaining dentist here. But I'm not going to give it away. I said I'll leave it to the end. I'm going to ignore that for now, because sometimes, sadly, even the HPCSA ignores this important misstep. And so, with that said, let's move on to the next chapter. And so then that takes us to chapter 2. And once the HPCSA complaint goes in, the registrar of the HPCSA must then appoint what is called an investigating officer to carry out an investigation, of course. And now this officer, on this occasion, because it doesn't always happen, on this occasion, this investigator decides that he's going to pitch up to Dr. Naidoo's practice without any notice. So he goes there unannounced, right? He arrives at Dr. Naidoo's reception and he introduces himself to the receptionist, says he's from the HPCSA. Receptionist then goes and calls Dr. Naidoo from the consulting room, and Dr. Naidoo then comes out, greets the investigating officer. And now, while Dr. Naidoo didn't pay too much attention in endo lectures when he was on campus, he used to listen very carefully to Dr. McKelvie from Dental Protection and all his presentations over the years. And one crucial bit of information that Dr. Naidoo remembered from these lectures, because he thought, it might come in use in future. He remembered that you must ask the investigating officer to give you proof in the form of a certificate that the HPCSA's investigator has actually been properly appointed. So Naidoo cleverly thinks to himself, he's clever, he says to the investigating officer, please, can you show me some proof that you're legitimate? And the investigating officer then takes out the certificate, shows it to Dr. Naidoo, it's all legit, right? And so the investigating officer then explains to Dr. Naidoo why he's here. He says, Doc, there's been a complaint about root canals. Here is a list of all the patients about whom there's been complaints, and all of these endodontic treatments have failed. What is going on? And then here's a bit of a twist in the story, right? Because there's a massive look of relief on Dr. Naidoo's face. And this is what he tells the officer. He says, Mr. Investigator, I don't do any endo work at my practice. I was never good at this thing on campus. And so when I get an endo patient, I always refer them to my locum. So all these patients you mentioned, they were not seen by me. They were seen by my locum. And look, I can even confirm this if I show you the patient files. And so Dr. Naidoo then takes some patient's files and shows them. He says, look, this is not my signature here next to the clinical notes. This is the so-called locum signature, right? And then, quite innocently, Dr. Naidoo says to the investigator, he says, this locum has been working at my practice for the last year, okay? The last year. But he just resigned and he moved to Australia because he's tired of this load shedding, right? And the investigator took down some notes and asked Dr. Naidoo for the locums in inverted commas details. And he said to Dr. Naidoo, I'm sorry, thank you very much for your time. Sorry for wasting too much of your time. Thank you for your cooperation. And Dr. Naidoo said to him, look, is there anything else that you need from me, Mr. Officer? And the investigator says, no, don't worry. I think you've cleared up everything. I think that's probably the last you'll hear from us, right? And of course, Dr. Naidoo was very happy and said, thank you very much, wish you well. And now, again, I'm going to pause here because some of you listening, and I've been dropping quite a strong hint here, but some of you listening who have some HPCSA or knowledge of the HPCSA rules, you'll probably pick up what I'm trying to hint on, which was quite an important mistake that Dr. Naidoo has made here, even though he thinks he's all in the clear. But I'm going to keep that to the end. I'll keep you in suspense for those who don't pick it up. So anyway, Dr. Naidoo, then he sleeps well at night. He knows he's off the hook, right? And the investigator then goes back to the HPCSA, to his office, and starts compiling his report. And now, because the investigator is not a dentist, he's not dentally qualified, not even anything in oral health, right? He focuses the report mainly on Dr. Naidoo, even though he knows the locum was doing the endos, because that way he can almost avoid dealing with the endodontic complaint, right? And so this investigator is doing some research and preparing his report. And while he's doing his research, he comes across ethical rule 9, which he had forgotten about when he was in Dr. Naidoo's practice. And you might think, well, how can he forget about a rule? He works for the HPCSA, but you'll all know that there's so many rules that it's often easy to overlook some, right? So he rediscovers ethical rule 9, and ethical rule 9 says you can only employ a locum for a maximum of 6 months. And now, if you could see the look on this investigator's face, he's so proud of himself for remembering or rediscovering this rule. And he thinks to himself, I've got you, Dr. Naidoo. So in his report, he says that Dr. Naidoo didn't perform the endo treatment. It was done by another practitioner. But Dr. Naidoo admits to contravening HPCSA ethical rule 9. And he recommends somewhat contradictorily the following. And this I've taken from an actual case, just to show you how there can be contradictory findings by the investigators. So the first thing that the investigator says is the file must be closed because Dr. Naidoo didn't do the endos, right? So you would think, okay, that's fine. File closed, investigation over. No, the next recommendation that the investigator makes, he says the matter must be reported to the HPCSA's complaints division because the conduct of employing a locum for more than 6 months contravenes the rules. So the investigator is recommending to the HPCSA, this must go for a formal inquiry. Meanwhile, remember, Dr. Naidoo is having a peaceful sleep. He doesn't have any idea what's to come. And that'll take us to chapter 3, right? So yeah, as I said, Dr. Naidoo carries on sleeping for the next 3 months. He has a peaceful sleep, right? While this report is being finalized and it goes through all the red tape and eventually it lands at the HPCSA's complaints handling division. So from the investigator, it goes back to the HPCSA's complaints handling division. And that took about 3 months, right? Now that complaints handling division then takes a few more months because the HPCSA, unfortunately, as with most places in this country, they're understaffed and they're overworked, but eventually they get to it and they eventually write to Dr. Naidoo. And so in the meanwhile, 6 months have transpired since Dr. Naidoo met the investigator. So 6 months later, Dr. Naidoo gets this email from the HPCSA saying that there's been a complaint against him. And this time, it's not a complaint by the doctor down the road, but of course, as you know, it's from the HPCSA's investigating officer. And in the email, the HPCSA then attaches the investigator's report, what they call it, the investigation report. And the investigation report shows that the officer has said that Dr. Naidoo breached the rules by employing a locum for more than 6 months. Now, remember, Naidoo had been sleeping for 6 months, and now he gets this email out of the blue, and he's furious because, the investigator told him 6 months ago, everything is fine. I don't think you'll hear anything from us. And here again, this is part of the very true part of the story because this exact thing happens quite often, sadly. So now that Dr. Naidoo's got this complaint, he has to respond formally in writing for something that he hasn't done. In his mind, this was a complaint about failed endos. Now it's turned into something about employing someone for more than 6 months. And Naidoo is thinking to himself, what's wrong with employing someone for more than 6 months? And I'm going to explain it on the next slide, but first, let me just tell you how the story ends, right? So, of course, now Dr. Naidoo then calls Dental Protection for help, and they get their experts and their panel lawyers who will then get as much information as possible from Dr. Naidoo. And it turns out that actually he hasn't done anything wrong. he's just made a mistake that many dentists and doctors and healthcare practitioners in general in South Africa make. He used the wrong terminology. So you see, he referred to his colleague who did the endos as a locum, but actually the colleague was not a locum, because locum is a very technical word and it has a very specific meaning, which I'm again going to explain later. So actually the doctor that was employed by Dr. Naidoo and moved to Australia wasn't a locum. They were actually an associate. This is what dental protection and Dr. Naidoo's lawyers then discover, right? So the lawyers then and dental protection helped Naidoo prepare a nice proper letter of explanation about this little misunderstanding. And they say to the HPCSA, please dismiss this complaint because actually no rules have been broken in fact, right? And then, and the reason why I'm telling you all of these processes and steps is I want to show you how things can take so long, even if it's such a simple matter, right? Because this letter of explanation then needs to be seen by the HPCSA's prelim committee of inquiry, right? And this committee is established by the Medical and Dental Board to conduct preliminary investigations of complaints and to make determination about these complaints. Now, the thing with this committee is that it only gets together every few months and it looks at a lot of complaints, not just one. So not just the complaint against Dr. Naidoo. So this kind of arrangement already delays things even more, right? And eventually when they do sit and they do consider, they look at the complaint, they look at Dr. Naidoo's letter of explanation and they make their decision. And eventually then they write to Dr. Naidoo's attorneys and they say the following. They say the prelim committee has had a look at Dr. Naidoo's explanation, but they are postponing their decision. They haven't made a decision yet because they want to hear from the so-called locum in Australia. Now, yeah, this person is down under, enjoying the electricity and, the time difference and everything. And so the HPCSA's complaints division takes even a few more months to get feedback from this dentist. And eventually after a few more months, they get that dentist in Australia, they get their feedback. It then comes back to the HPCSA, have to wait another few months for the next prelim committee meeting. And eventually this prelim committee meets again. They reconsider everything and they see their feedback from the Australian. And they finally make their decision and they say that, okay, fine, Dr. Naidoo is off the hook. He hasn't contravened anything. And they write back to Dr. Naidoo a few months later. And eventually, after almost 2 years since the day that the investigator came to Dr. Naidoo's practice, almost 2 years later, he finds out that the matter is finally closed, right? And all of this is because he slipped up and he used the wrong word. And it was innocent. He didn't even mean anything by it. It took two years out of his life. So that's how the curious case of the complaint against the confused colleague came to an end. It ended in 2 years of sleepless nights for an innocent dentist, which he won't get back. The only good news from this whole story is that everybody's root canals are now safe. Okay. So I said we'll look at a few learnings from the problem areas that I hinted about along the way. So firstly, complaints against colleagues, right? Now, the HPCSA is quite clear. Ethical Rule 25 says that you must report. It uses the word shall, and shall in legalese means must. It says you must report to the HPCSA any unprofessional, illegal, or unethical conduct of another practitioner. Now, those are three separate things because unprofessional conduct is what your profession and what your regulator dictates or determines, and the profession. Illegal is something that if there's a law against it, it's illegal, it's unlawful. And then again, unethical is again determined by the profession itself. So it's a very wide range of things that you must report. But this doesn't mean that if you get the slight hint or a suspicion of this kind of conduct, then you must immediately go running to the HPCSA. They're not the Impimpa hotline or whatever, because there's another ethical rule which says that you must not cast reflections on the professional reputation or skill of another person registered with the HPCSA. So essentially what they're saying is don't speak badly about your colleagues. So there's two conflicting rules there. One says you must report, the other one says you mustn't speak badly about your colleagues. So you need to really be sure about it before you go and report. And remember, at the end of the day, we are all colleagues here, and we need to uphold the reputation of our profession, because if we ever get the reputation of unnecessarily throwing stones at one another, then ultimately it's the reputation of the whole profession of dentists who could suffer, and look bad in the eyes of the public. So for example, if we are fighting with one another on social media, for example, patients see this because it's a public platform. It affects all of us, not just the two doctors who are doing the fighting. And so when you have a kind of situation like this, like for example, the one with Dr. Naidoo and his endos, one of the useful bits of advice, if you're faced with this kind of thing, or this kind of patient coming from Naidoo's practice, before complaining, you can consider engaging meaningfully with Dr. Naidoo. And remember, even the supersession discussion that Alisdais had earlier, and we has explained how to deal with that kind of situation. But if you look at the story that I just told you now, can you imagine how much trouble could have been avoided if there was simply some communication between the practitioners? It could have helped to identify a problem and resolve a problem, which ultimately would have benefited the patients. And we're all here ultimately for the benefit of the patient. Now, don't get me wrong, we do understand that sometimes it's uncomfortable to have this kind of conversation, and it's not attractive. Not everybody wants to go to a colleague and say, this is what I've noticed. But you must remember, in any case, if you decide to go the direct route to the HPCSA without consulting your colleague, eventually it can come to light that you were the one that lodged the complaint, and you may even be called as a witness if formal disciplinary proceedings happen at the HPCSA down the line, right? So that's one option. You can also suggest to the patients that they go back to the practice, the original practice, and if nothing is resolved, they can consider complaining directly to the HPCSA themselves, and that can also help to potentially avoid the next problem, which I'm going to talk about. And so there are many steps to consider to address a problematic colleague before you go straight to the HPCSA in most cases. And I say in most cases because there are definitely going to be some cases where it's not advisable at all for you to go and speak to the other practitioner, and it justifies you going straight to the HPCSA. But those are probably very few and far between. Okay. Then problem number 2 on the screen, which I alluded to and I hinted at. And you would have picked this up, some of you. I even see a question about disclosing patient information. I saw it pop up on my screen. So that person who posted that question will have picked this up. And it's, remember I said that the complaining dentist attached all the patient records to the complaint. And you will remember that patient information is special personal information. And I'm not saying it's special because I think it's special. That's what the law says, papaya or poppy or whatever you call it. It says that health information is special personal information. And also the HPCSA's rules about confidentiality apply. So you should only ever disclose patient information to third parties, including the HPCSA. And I must say, including the HPCSA, because sometimes we receive these letters from the HPCSA asking us for information. And we think, wow, it's the HPCSA, this big regulator. Surely they wouldn't ask for something they're not entitled to. But even they need to provide you with the patient's consent before you can disclose anything to them or other third parties. Now, there are exceptions to this, but these exceptions are so exceptional, I'm not even going to mention them in this talk. So the complaining dentist here, when they attached, they were doing it out of the goodness of their heart to say, I'm trying to protect these patients. But when they attached those records, they are opening themselves up potentially to a complaint, firstly from the patient. If the patient ever discovers that the other dentist disclosed, they could get a complaint. And then secondly, they're opening themselves up to being in trouble with even the the information regulator for a breach of POPI provisions. And all of this in the name of trying to protect the patient from harm. So must remember that. And then lastly, number 3, what is a locum? And I think now it will probably make more sense why I've put it there in this talk. And I'm not sure how this has come about in South Africa. It might be like the myth that, you know, saying sorry means you're admitting guilt. That's a myth. It's not true. But in South Africa, I can tell, you know, I can't tell you how often I see this. And to be honest, I was guilty of this when I was a dentist and before I became a lawyer. It's this. In South Africa, we seem to use the term locum incorrectly. Now, if you go and dig into one of the South African dental journals, I like this description. There's a 2015 July edition, volume 70. Prof. Naidoo gives a description of what a locum is. And I always quote it because I like the description. And it says, a locum is a position that is offered when a practitioner in private practice is going on holiday, attending a congress, taking study leave, or is absent from practice due to illness or other reason, and therefore the appointment is of short duration. Right? So that's the description of a locum. But in South Africa, I see quite often we use it almost interchangeably to describe someone who works at a practice permanently, but is not the owner of the practice. Right? So essentially, it's used interchangeably with an associate or an independent contractor or an employee. And the HPCSA's ethical rule is clear. Rule 9, you can't employ a locum for more than 9 months. So when Dr. Naidoo innocently used the term, he said, no, that's my locum. He's been here for the past year, but he's moved over. What he actually meant was an associate or an independent contractor. He inadvertently said to the investigator, oh yeah, I broke the rules. I employed this locum for more than 6 months. And so in the story, when Dr. Naidoo's lawyers and dental protection helped to prepare the letter of explanation to the HPCSA, they explained to the HPCSA, they said, look, Dr. Naidoo used the term innocently, but it was incorrect. He didn't mean locum. What he meant was associate. And that clarified it, and that's why the prelim committee accepted it. So, you know, let's try and break that myth and break this misconception. Remember what a locum is, and also remember, we're not just telling you all these definitions of locum and definitions of supersession just because you need to memorize it and it's just something you must know. It actually, if you get these things wrong sometimes in real life, you can innocently get yourself in trouble and be having sleepless nights for years to come. So with that, I'll thank you for listening to my story, and I hope it's been useful. I'm going to hand over to my colleague Zodwa Mahlangu for the application process. Thanks. Over to you, Zodwa.
Good evening, everyone. My name is Zodwa Mahlangu, and I am the relationship manager. My talk is very short, and I'll be taking you through the application process in terms of how to become a dental protection member. So the process is very easy. You would first need to go to the DPA website from your browser. If you type www.dpa.org.za, you will see from the menu, they've got different adverts going on, but on the top, there is a tab there. When you're looking at my screen, it is circled in red. It's dental protection tab. When you click on that tab, it will then take you through the short screen that you can see below there. It would say join dental protection, where you need to complete the online form. It's a very quick form. Basically, it will ask you your personal details, name, surname, email address, phone number, HPCSA number. And if you wish, you can type in your message in terms of how you would like dental protection to assist you. So you can type in your scope of practice and let us know if you want a quotation or you want to know what the membership benefits are. It depends. Or you can just ask to join from that page. Once we get that form on our side, we will then send you a grade sheet. So the grade sheet is what you see now on your screen. On the left-hand side, you will see there's a description of grades. And on top, we've got different hours. So the first thing that you would need to do is to identify the correct scope of practice. Once you have identified that, you look on top to see the number of working hours per week. Now, like Dr. Yash Naidoo said, we've got locum hours. So now that you know what the meaning or the definition of locum is, you would then have to choose according to the description that has been given from this event. So we've got the first one up to 11 hours per week. Then we've got 11 to 22 hours. And then we've got 22 hours to 33 hours. And the last one is full-time private practice, which is more than 33 hours per week. Now, for instance, if you are doing, you're a general dental practitioner, you will also look at, you will see there are ticks and crosses. It will explain what the tick is for if you're doing specified procedures, maxillofacial procedures. Where there is a tick, it then means it is included in that grade. If there's a cross, then it won't be included. Then you'd look at the grades that would be best suitable for you. For instance, the general one that we usually get, especially from DPA's members, is the DDP, where it's general dentistry, where there is no procedures that are being done. And when I'm saying procedures, on the form, when you get it, there are explanations of what falls under specified procedures and what falls under maxillofacial procedures, dental alveolar procedures. So you will have to go through the grade sheet for you to identify the types of procedures, and you come back and link it to this page. And you will be able to choose or identify the correct grade. Once we have that information, we would have obviously the quotation sent through. You will get the application form. It is PDF editable. You will see from the screen, there are 3 screenshots. You will need to please complete everything because we will need to have all the information before we send it through for processing. The first section, or rather the first page, as I've said before, it's editable. You can complete the form using your cell phone. You can use your iPad or your laptop. You don't necessarily need to print it. I know there are members like me who are still old-fashioned. They prefer to use a pen. So you're still welcome to print and whichever is suitable for you, we would welcome the form. However, if you're going to use a pen, please write eligibly, because most handwritings are difficult to read. So you will have to complete your personal details. The very first top question there, it would ask you if you would like a specific start date. Now, the reason why we've got it there, it is because you might be taking membership, or rather completing the form today, but you're only going to start the job on the 1st of July. You just want to get all your ducks in a row. Now, with our process, when we get the completed application form today, your membership will start the next day, which is tomorrow. Now, to avoid that, should you wish that we started on a specific date, then you will have to give us that preferred date right in the beginning. We then have the second section, section B. This is mostly your claims history. It's few questions that you need to answer very honestly. It's a yes or no. And if it's a yes, you would be requested to give details. I know there are questions there, especially question 3, where it's basically asking you if you have ever practiced without indemnity. If it's yes, then you would need to say the reasons why and from when, the period of time. So all these questions need to be answered. And there is a blank page. Should perhaps the space not be enough, then you can refer us on the blank page and inform us that this is a continuation of question 3 or question 7, and then continue giving us the details. The last section, we have a declaration. Now, as you are aware, due to POPIA, we do need you to consent to us keeping your personal information. So you need to consent. Please, you need to tick on that I consent, accepting the declaration. Then you have to sign and date the form. The application process in short. So once we have received the form, it will go through to the South African Medical Association, who is going to then capture it and check that all the details that are on the form are the same as the ones which reflect on the HPCSA system. From there, the form will be sent to our international office for vetting. Then it will be sent through to our underwriting team for evaluation. And this happens mostly for members who have had cases before. From there, it will go to pricing. Once it comes back from pricing, the international office will send you an approval confirmation. Once you get the approval, that's when you can choose your preferred method of payment. So we've got 3 types. The first one is a full payment, which can be done as an EFT, or it can be done on a debit order, which is the second option. And the third option, which is most chosen by, or rather preferred by most members, is the 10-month monthly debit orders. Once we've received the preferred payment method, we will then send you the DP proof of indemnity, which usually you can submit to your employer that you are now protected. Usually the processing time is estimated to take 5 to 10 working days. It's quicker if there are no errors on the application form. This is my virtual business card. Please feel free to take my details. If you've got any questions, you can send me a WhatsApp, email, or call me during office hours, and I'll be happy to answer any membership related questions, and especially in terms of how to join. If it's any dental legal advice required, I will also give you the contact details, who you would need to speak to. Thank you.
Okay, thank you so much to you, Zodwa, and the other panelists, Alisdais and Dr. Yash. I would assume that we were scheduled to finish at 8:30 South African time. However, we have some few questions, and we will endeavor to answer the questions, and then thereafter we will be able to close the webinar session. Yes, let's get right into the questions. I think the first one relates to the Supersession. Alisdais, are you able to read that?
Yeah, yeah, it's very simple. There is an expectation that what a patient says in answer to your questions is the absolute truth. And whatever you ask the patient about supersession, are you under treatment with another dentist, and they say no when they obviously are, then you write down in the treatment notes that you asked the patient if they're under treatment and they said no, and you write that down in the records. And there's nothing more that you can do about it. But if you are clearly uncomfortable about the fact that the patient's trying to mislead you, it's not really a very helpful thing in terms of a professional relationship, which is built on trust. And I think, if there is something really obviously wrong there that the patient is concealing, you've just got to say to them, look, if you've given me misleading information, it could have an impact on how I go about your treatment. And the perfect example is that there may be up-to-date radiographs and clinical information that would actually help the continuation of the treatment. So it's about asking questions, it's about checking the patient understands the question that's been asked. And if you don't feel something's right, then you must say so. But if the patient answers a question and you're unsure about or uncertain about the answer they've given you, then just please make a record of what they said in the treatment records, because you've no reason to write anything else other than what was truthfully said to you at the time. So that would be my advice.
Okay, awesome. Personally, I wanted to ask a whole lot more questions regarding vicarious liability, but it looks like it's a topic on its own for another day. The one issue that I picked up from your presentation, Alisdais, related to informed consent. I think you referred specifically to root canal treatment. But what does it mean? Should we have informed consent for each and every procedure, let alone root canal, but whether it's extractions, whether it's surgical extractions, whether it is a class 2 filling, or whatever the case may be, or is one informed consent form done, when you first see the patient, sufficient to cover the practice, for all other treatments that will follow?
It's very difficult to answer that question in the time available, Thabo, but consent is an ongoing process, and I don't want people to get bogged down in it being something that's really difficult to do. Essentially, what you're doing when a patient walks in for treatment is that you're carrying out an examination. You're deciding what's wrong with them. You reach a diagnosis. You know that with this particular condition, there are a number of options for treatment. You explain those options to the patient. You tell them which is more likely to succeed. You tell them what the risks are if something does go wrong, and you tell them what the cost of that treatment is. And if the patient says, yes, I want you to proceed with that treatment, then you've got consent. Okay, so the consent is all about a conversation. The actual writing in the consent form is not necessary to prove that a valid consent has been obtained, but it's really helpful if there is something written in the records. And this is why it's really important to structure your record correctly. We're not saying you have to write chapters and chapters of information, but you know, the basics. What's the patient wanting? Why are they here? What's the problem? What's their condition? What's the diagnosis? What treatment is available for them? And what have they agreed based on the information you've given them? And you can write that down in your treatment notes. You don't need to give them a form to sign to say that consent has been given, but it is helpful, providing that consent form is not generic and providing that consent form is specific to that particular patient's needs. So that's really the thing about consent, is you get it at the outset, but patient comes back for the second visit, which is maybe to fit the crown, and you say, right, hi, how did it go? You know what we're doing today. We're going to be fitting that crown that we prepared the tooth for last visit. Are you happy for me to proceed? And I'm going to give you some local anesthetic, and the patient just nods, and you've got consent to do that. So it is important that whatever treatment, whatever intervention is going to be provided, that the patient has agreed for you to proceed with that treatment based on the patient making a decision based on a reasonable amount of information that they need to make that decision. So that's how I think we should be approaching consent. And maybe Yash can help me out here if he thinks there's anything I'd missed out in that answer.
No, nothing to add. I think you've dealt with it comprehensively.
So okay. Your question was, Tabo, if you, let's just say if you're doing a filling, okay, and you said to the patient, look, I'm going to do a filling, there's a bit of decay in this tooth, everything is fine, and then all of a sudden you suddenly see the pulp sitting there facing you, and it's bleeding, and you realize that this is an inflamed pulp. Now, you can't go ahead and extirpate the pulp until you've told the patient that that's where you've got in the treatment. So you need to have permission to extirpate the pulp. You can't just go ahead and do it if you haven't spoken about it.
Okay, no, that's fine. That's fine. I'm sure it's also a topic for another day. Okay, I think Dr. Yash will deal with some of the questions that arise here. The one question from Dr. Machava about how to identify HPCSA inspectors. Should they not even make an appointment if ever they want to see? Should they, are they allowed to just present themselves without letting you know?
Yeah, it's a good question by Dr. Machava, and I'm glad he asked it, or she asked it, because firstly, they shouldn't just be hopping into your practices regularly. It shouldn't happen. Importantly, they must give you a certificate. So you must ask them, say to them, can you show me your certificate of appointment by the registrar? Business card is not good enough. Secondly, sometimes they come and say, I want to search, or I want to have a look, or I want to make copies. In that case, you actually need to ask them for a copy of a search warrant. And I know it sounds a bit obstructive, but it's a requirement. And if you're not sure, tell them, look, I'm calling my defense organization or my indemnifier or whoever before I do anything. It's always safest, because they can sit there in the waiting room and you can call and get advice before. But certificate, and if they want to search, a search warrant. Very important, yeah. And to your point, Dr. Twala, of appointments, they should, and they generally do, but there's sometimes good cause or good reason for them not to make an appointment, depending on the complaint, where they don't want to give the practitioner an opportunity, to sort of make things pretty. Yeah.
Okay, you may want to deal with the issues regarding disclosure of records to third parties, Alisdais.
Yeah,
like medical funders.
I mean, that's very simple answer. It's not only about ethics; it's about what you're legally allowed to do here. And the answer is, I mean, Yash gave the answer in his presentation, is that you need the patient to consent before you disclose information to a third-party funder. The third-party funder may have got the patient to sign a consent form for them to see their clinical information from a record card, but that consent form doesn't give the dentist permission to disclose the information. So if a medical aid comes to you and gives you a list of records that they want to have a look at, then you cannot disclose that information lawfully unless you've got the patient's permission, and you need to say that to them.
Yeah, I think I totally agree with you on that one, except that we are sitting with between a rock and a hard place. Mm-hmm. Because what actually happens in practice is that the funder will block payments to the practice as a way of putting pressure, and ultimately the practitioner will buckle under pressure, because financially they'll put you in a very difficult position.
And that's completely unlawful as well for the medical aid to block payments to the practitioner. I mean, they've got to be held accountable here, and that's why you're able to make a complaint to the council of the medical schemes about all of this, because there's a lot of case law about this now, Thabo, and it's becoming clearer and clearer what they can and they can't get away with. But it's not that you're being obstructive, it's just that as a dentist or a doctor, you have a professional and a statutory responsibility to protect the special personal information that you've got for your patients, and you obviously want to help. And the best way of doing this, to do it lawfully, is you've got a list of patients, you get your receptionist to phone them up and say, we've had a request from Benitez or James or whoever, and they want to see your records. Are you happy for us to disclose them? And if the patient says yes, you disclose them. If the patient says no, you write back to the medical scheme and says, we've advised the patient that you want to see the records, but they've actually given us they've declined permission for us to carry out this function. You'll need to deal with the patient yourself.
Yeah. Okay, that's fine. There's a question regarding the relationship between GPA and Delta, but I think I will deal with it after we have done. There's some people, they asked their questions on the chat group. Can you see that, Zodwa, rather than on the Q&A?
Yeah.
Yeah.
There's one a quick one that I can deal with, where it says, it's by Penelope, how would you then define an associate? An associate is essentially somebody who works at the practice but it's not the owner of the practice. It can be an employee, it can be an independent contractor, and that will depend on the actual agreement that you have between yourself as the owner and that person. So that's the quick short answer to it.
Okay, and then there's another one there, Thabo. If a patient wants to go and continue their orthodontic treatment with another dentist or orthodontist, are we allowed to withhold their records until they settle the balance on their account?
Yes.
I mean, the issue here is that the account may not be being paid by the patient. The patient may be a child, and the account may be unpaid by the parent. But there's not a lot of guidance around this, but there is some ethical rules around obstructing patients making decisions about where they have their treatment from. And I think if you refuse to provide the information from your treatment records until the patient paid their account, I think that the HPCSA would find that something that they would disapprove of. I think you disclose the records and separately you deal with the outstanding account. You don't let the outstanding account get in the way of the patient's care, because you're not acting in the patient's best interest there. It's probably not a popular answer, but I think that's the way the HPCSA would see it.
I'm certain it's not popular. Okay, let's see. How do I check if I'm registered for dental protection, as I cannot remember if I'm on the list? Zodwa, would you be able to answer that one?
The, there's one, a quick one that I can deal with, where it says, how would you then define an associate? An associate is essentially somebody who works at the practice but it's not the owner of the practice. It can be an employee, it can be an independent contractor, and that will depend on the actual agreement that you have between yourself as the owner and that person. So that's the quick short answer to it.
Okay,
Yes, so the member can send me an email with their details. I'll be able to check. Or if they were not able to take my email address, they can go to the DPA's website and just complete that form. Under the comments section, just ask me to check if you are a member or not, and I'll be able to respond.
Now there's okay, thanks, Zodwa. There's another one there. Do you see?
From Dudu.
Is it Dudu? Is it? I'm not too sure if it's Dudu, but regarding a pending case. Are you able to see that?
Which is the one I'm looking at is the employing dental therapists to allow them to carry out their ComServe year.
Yes, so, okay.
So do you, I mean, I think the answer to this question is that they're not coming to your practice to fill in for your therapist's absence or their holiday. They're coming there to work to your practice for a year, so they're never going to be called a locum. So you're probably going to employ that therapist, but we all have a problem there because the therapist comes to your practice rather than to do their ComServe in the public sector. And we don't know who's indemnifying that therapist who comes to your private practice rather than for them working in the public sector. So there is an issue there. There's an unresolved issue there about who provides the indemnity for that therapist who carries out ComServe in a private practice. And I think that whoever's come to decide that this is probably the way forward hasn't taken into account the indemnity position of the private practitioner. So there is a problem that needs to be resolved in that relationship if the therapist is doing their ComServe in a private practice.
Yeah, I think also it could be a topic that we may have to deal with, because they are not entirely doing community service. There is this thing called supervised clinical practice, which newly graduated dental therapists are required to do before they can be registered as independent practitioners by the HPCSA. Yeah. So that can be done in either public service or or in the private.
Yeah, and
I think the issue of indemnity is the one that is important. Who's going to provide indemnity during that period? I think that is probably the issue that we will need to look at.
If they're doing this year in a private practice, then the indemnity for that needs to be paid for by the therapist or the dentist who employs the therapist. So Zod would be able to help with that one because we provide indemnity for therapists and for oral hygienists as well.
Yes, so I think the most important thing is that generally as dentists and people who employ dental therapists and even oral hygienists and even other dentists, we really need to start looking very seriously onto the issues regarding indemnity and vicarious liability and all those things. So I think what you presented today is absolutely important. Okay, there's the issue regarding disclosing records. I think we have dealt with. No, I don't think so. There's always an issue disclosing patient records to third parties where authorizations are required prior to commencement of treatment, right? So you have to disclose patient records prior to commencement of treatment. I'm not too sure what the question is. Should we do it? Shouldn't we do it? What do you think? Let's say you need authorization for, let's say to put in an implant, for instance, but you need to show the medical aid that there's an edentulous space there.
I mean, you're going to be saying to your patient, I need authorization from your medical scheme. I need to share information with them to get this authorization. So the patient's already giving you your consent to do that, and you say, if I don't have this authorization, I can't go ahead with the treatment. But the forensic audits that medical schemes are carrying out unrelated to treatment is a completely different request for information.
I suppose if the patient says go ahead and get authorization, I mean that in itself is consent, right?
Exactly.
Okay. There's this one. I wonder if ever you can read it, Alisdais.
Yeah.
What if I need cover, but I have a pending case? I suppose it's through the HPCSA. Are you able to assist with that case?
Okay, so the reading of this is that this colleague has an unresolved HPCSA investigation going on, and when he applied for to join Dental Protection, the decision was that we wouldn't indemnify him because of this outstanding HPCSA case. And I guess the only way to look at this is to pick this up offline, and I don't know if you can contact Zodwa, and we'll take this forward and see what the problem is. But we would really need some information about the ongoing HPCSA case, who's providing your representation, what's the current status of the case, and there's no reason why you shouldn't ask the HPCSA what's happening with this matter. And it may well be sitting in a drawer at the bottom of somebody's desk and being completely forgotten about, which is unhelpful. But I think, you know, if there is an unresolved decision with the HPCSA, then our underwriting team have looked at it. But if you contact Zodwa directly, then we can maybe look at this and see what the situation is, and if we can somehow manage to provide you with membership of Dental Protection. I don't know until I see all the information.
Yes, I think that's a fair question. So the colleague will be advised to contact Zodwa, and then she will assist to find a resolution to the matter. Okay, I haven't actually read the next one, but there's a scenario. Did you manage to read it? Is it you, Yash?
Let's read the scenario. So a patient makes an appointment with me, his first time visit to my practice, and he's not familiar with the town. Directions given. Unfortunately, on the day of the appointment, the patient got lost and landed in another dentist next street. Patient made it clear, I want Dr. X, but he was convinced the other doctor can also assist. Okay, so he was treated. When the receptionist realizes the patient hasn't arrived yet because it is past appointment time, she calls the patient, and the patient says he's already got treated by the doctor on the next street. Now, that's an interesting one.
I mean, my immediate thoughts are it just, shrug of the shoulders. There's nothing you can do there because there is no contractual arrangement with that patient. So, if you said, right, I booked him in for 30 minutes for an examination and he didn't show, and I want all the money for the 30 minutes that my time that was wasted, I'm afraid you're not going to get that money back. It's just one of those things. And is it an ethical issue with the other practitioner? I don't know. It depends what the patient said when they turned up, whether he just pretended he was a walk-in or whatever. You just never know what happens in these situations. But you probably don't want a dopey patient like this because they'll always turn up late for their appointment. So it's probably a good thing that they've gone to somebody else, and that's the way that you've got to look at this.
And I suspect there's more to this, because how would we know that the patient made it clear to Dr. X that they want the other doctor? There must be more to this, but yeah.
Yeah. Look, I think it just makes the point that, there's so many, there's such a variety of instances and cases and incidences that, that can possibly happen, and which is why you probably need to have professionals, looking after your indemnity issues.
I mean, I think there are other things that you cannot control, Thabo, and you cannot control your patients. You just hope that your patients respect you, respect the time that you set aside for them, that they pay your bills, and it's the ones that don't respect us, the ones that don't pay our bills, that we get very stressed out about, and that's the difficult thing, is because it's very difficult not to get stressed out. I mean, dentistry is hard enough without having to deal with the business side of it and the behavior of patients. If we could just treat the person who comes into the surgery, they open their mouth and you get on with the job in hand, it would be a lovely profession to be part of, and the job would be very rewarding. But sometimes you have these very difficult individuals attached to the teeth and the gums. It's just part of life, is that there are some times that we win, sometimes we lose. And we must never lose sight of the fact that most of our patients really appreciate what we do, and the small people that don't deserve the care and attention that we give them. And you've just got to look at life that way as a dentist.
Okay, that's fine. I think it's time for me to answer the question regarding the relationship between DPA and dental protection, and you Zodwa and Alisdais can assist. So the dental protection is a partner of the DPA in relation to providing professional indemnity and other indemnity-related, services to the DPA. The question is, do you have to be a member of the DPA in order to be able to join protection? And the answer to that is categorically not. You do not have to be a member of the DPA in order to access dental protection. For us, it is absolutely important that every dentist should have professional indemnity, and therefore we haven't tied our relationship with dental protection to specifically the membership of the DPA. Obviously, we would like as many people to join the DPA as possible. But in terms of joining dental protection, you do not necessarily have to be a member of the DPA. You will find the dental protection details on the DPA website, and then you can use those details to apply for dental protection. But you do not necessarily have to be a member of the DPA. I hope it is very clear.
Yeah, just to pick up on that one, Thabo. I think that the question was, do I need to be a member of the DPA to get dental protection? And you're right, the answer is no, but we'd really want people to be members of DPA and members of dental protection. But if for some reason you didn't want to be a member of DPA, then you go to our website, our www.dentalprotection.org, at the South African section of it, and you can fill in an application form on our website. It's no problem at all. So there's lots of ways of joining dental protection, but we've got the special relationship with the DPA. We've also got a special relationship with SADA. And we want to be part of the profession, and we want the profession to be part of us, and we want to have these important relationships. But if you don't want to be a member of any association, that's fine. It doesn't stop you applying for your indemnity. You can still have indemnity from dental protection.
Absolutely. I hope it is very clear. Zodwa?
Yeah, you covered nothing to add, Dr. Tyler. Thank you.
Okay, fantastic. But please do join the DPA. Okay. Yeah, I think we have done well with most of the questions. If there aren't, I really think that we have. Besides that, I think we are running out of time as well. So let me take this opportunity to thank the panelists. Thanks to you, Zodwa, for putting it together. I know you've really suffered a bit to make sure that it does finally take place. And thanks to you, as always, for the wonderful presentations. You, Alisdais and Yash. I mean, this is the second time now that we were having this. And the presentations were absolutely stunning. And I would like to thank all the delegates who joined us today. I mean, this is probably one of the best attended webinars that we have had in the DPA. And I would assume in various other platforms as well. I mean, to get so many people attending a webinar is probably, it means that it was a special occasion. And thank you so much, and good evening to everyone.
And just from me on behalf of Dental Protection, Thabo, thank you for our relationship. Our friendship goes back many, many years. and it's a pleasure to be serving your members and our members as well here on this platform. Can I just remind everybody that the feedback is important, and if there are any other housekeeping rules that that Zodwa thinks I haven't mentioned, then maybe she can step in. But it's thanks to Zodwa, Yash, and to you, Thabo, for allowing us this, and to all the delegates who have had load shedding or not load shedding for giving us an hour and a half of their time. Thank you very, very much.
And the feedback, how do we input the feedback? Do you know, Alisdais?
So after we end this webinar, there will be a pop-up screen with questions. That's how we are going to get the feedback.
All right, fantastic. Thank you so much. Good night, everyone.
Good night, Thabo.
Thank you. Goodbye.
Thank you. Bye-bye.